Hello, everybody. My name is Gary Fritz, and I'm here today to give my case presentation in the class of Cannabis and the Law. My case presentation today will be U.S. versus McIntosh. Okay, today is April 5th, 2021. Cannabis and the Law, U.S. versus McIntosh. The first question that we were to address is identify what the problem is in the case file. My interpretation of the problem is that the appellants allege that the government is prohibited from spending funds to prosecute them because Section 542 of the Appropriations Bill solely prohibits the federal government from preventing the implementation of the state laws that authorize individuals from using, distributing, possessing, or cultivating medical marijuana. This case has 10 different defendants that were grouped together, and the cases range from locationally, California to Washington. The 10 defendants were indicted on a variety of federal charges. The 10 defendants fought the charges in the lower courts with no success. From there, they brought the case to the 9th U.S. Court of Appeals, 9th District of the U.S. Court of Appeals. The court concluded that the appellants did have legal standing to invoke separation of powers provision of the Constitution to challenge their criminal prosecutions. The defendants moved to show they were authorized. A key question for the U.S. courts is were the 10 defendants compliant and authorized, and were they not breaking the state's law on the Controlled Substances Act? But if they are not authorized through the state, and they do break the Controlled Substances Act, they will feel the complete authority of the Department of Justice and subsequent prosecution. I found this interesting how first you establish jurisdiction and then the appropriateness of the U.S. court stepping in while the 10 are being prosecuted. It seemed like a favorable decision by the 9th Circuit of U.S. Appeals. It prohibited the Department of Justice from spending funds from relevant funds from appropriations for the prosecution of individuals. These individuals who engaged in conduct were compliant and were permitted by the state medical marijuana laws in their state. Okay, describe the facts of the matter. There's originally, medical marijuana was originally a big issue in 2001 at the U.S. House of Representatives called the Rohrabacher-Farr Amendment. The passage of this amendment became law in December 2014. This was the first time either chamber voted to protect medical cannabis laws. And should people be subject to the power and ruthless, uncontrolled power of the Department of Justice when the people were acting lawfully and compliant? I think that's one of the major issues. I think that they were being compliant with their state, and federal government was being overzealous in the prosecution of these individuals and businesses. This is a major landmark case because the 10 individuals were compliant within their own state regulations. The case is limited in coverage. The U.S. appellate court system has 13 circuits. Disappointing was the fact that 9th Circuit only covers 9 states and Guam and Northern Marianas Islands. One can only hope that this ruling might help slow down the many more cases of unfair prosecution, indictments, harassment, or legal costs being filed against new law-abiding compliant people. It is very important to know that this case matter only covers medical marijuana, not recreational. The current state of the matter, the cases were remanded back to the appropriate district courts to make sure they were compliant with their own state. The federal government and Department of Justice will always be powerful and a force to be dealt with in the legalization of marijuana. One must note that marijuana production is still a crime. No state can legalize possession, distribution, or manufacturing of marijuana. All such activity remains prohibited by federal law. The court further explains that people may not be prosecuted, but it's only because that within the authority and compliance of their state's regulations. Okay. And the third question, current state of the matter, any conduct that is unauthorized will be prosecuted for violating the Controlled Substance Act. Under the Supremacy Clause of the Constitution, laws cannot permit what federal law prohibits. Thus, while the Controlled Substance Act remains in effect, states cannot authorize the manufacturing, using, distributing, possessing, or cultivating medical marijuana. Congress at any time could appropriate funds to prosecute. Now, question number 4 was, why is the legal matter important, in my opinion, as a consumer, employee, dispensary, cultivation employee, on a legal matter in day-to-day operations? My answer is clearly that all of these actions are still breaking federal laws, even though you are compliant with state laws and regulations. The McIntosh case is progressive, and as it goes forward, there's still room for much progress, and that's about the way I see it. Thank you very much. Bye.